In this training module, I'm going to explain what qualifies as prior art that could be used to stop you from getting a patent on your invention. This includes reviewing applicable language in Section 102 from Title 35 of the U.S. Code, and understanding what types of documented evidence qualify as prior art. By the end of this training module, you should be able to generally identify prior art references. Let's get started. So I want to refer to the list on the screen. This list is very similar. In fact, you might recognize it from one of the prior training modules that we did on confidentiality and public disclosure. Those are the types of activities that we described then that could keep you from getting a patent on your invention. Well, that list came from Section 102 of Title 35 of the U.S. Code. This is the controlling patent law that designates what qualifies as prior art. So if we look at this list, we can see the types of activities that could bar us from getting a patent. These types of activities also relate to prior art. Any documentation of these activities will qualify as prior art. Now, prior art is important because it's exactly what the patent office and the patent examiners will go find so that they can then examine your patent application and determine whether or not you're entitled to an issued patent. We're going to look at two different groupings from Section 102. They're in subsections A1 and subsections A2. Let's start with subsection A1 on the screen. So no patent is available if your claimed invention was either patented, described in a printed publication, in public use, on sale, or otherwise available to the public before the effective filing date of your application. So a patent is considered prior art if the patent was issued before the effective filing date of your application. If you were to file a patent application today and there was a patent that issued yesterday on that same invention, then you would not be entitled to a patent yourself. Likewise, if there was a patent that issued 80 years ago, you would not be able to get a patent on your invention today. Likewise, if your invention was described in a printed publication of any sort, this isn't limited to patent documents. It can be a publication in a magazine, in a newspaper, in a journal. It could be on the internet. Wherever it is doesn't really matter as long as it's been printed and published and available to the public. And as long as that publication took place prior to the date of your filing for your patent application, you won't be able to get a patent. In terms of public use and on-sale types of activities, there isn't necessarily a specific document like a patent or a publication that will show the use or sale. However, any documentation that references this to show or imply that there was public use or on sale could be considered prior art. It's also important to note that an applicant, you as an applicant, can admit to prior art. Just like on a popular crime show on TV, when a policeman says to somebody, anything that you say can and will be used against you in a court of law. The same thing applies here. Anything that you admit to the patent office, or perhaps even if you admitted to it in a different type of document that then later became available to the patent office, that could be used against you as what is called applicant admitted prior art, or AAPA sometimes, in an office action. And so remember, anything that you say or any documentation that's available to the patent office will be used by the patent office when they evaluate your patent application and could stop you from getting a patent. Now let's look at subsection 102A2. This is very similar to the other language that we just looked at. No patent is available if your claimed invention was described in a patent or described in a printed publication, filed by another inventor, before the effective filing date of your application. What I want to point out here is that this section is a little bit different than the prior section. The prior section can be prior art generated by anyone, including yourself. It doesn't have to be publications by other people. Here, for 102A2, the publication has to be described in a patent or printed publication filed by another inventor. So what you find here is that the documentation to qualify as prior art under this subsection specifically has to be by another inventor. In this case, another inventor means another inventive entity. What does that mean? An inventive entity is made up of all the inventors on a single document, on a single patent application. And so if you have, say, 3 inventors, Rick, Tom, and Joe, on one patent application, let's say in a second scenario that Rick and Tom go off and they invent something else, but instead of Joe being involved, they have Danny involved. Well, once you have a different set of inventors on a patent application, that is considered to be filed by another inventor, even though there's some overlapping inventors on both applications. The other thing to note that's different from section A1, this section A2 goes off of the filing date of the patent or printed publication, whereas subsection A1 went off of the actual patent date, or the date that it was issued, or the publication date itself. There are scenarios where even though an application is not published until after you file your patent application, if it was filed before you filed your patent application, then this section would apply, and that patent or printed publication could also be considered prior art. In this situation, a printed publication is probably limited to a patent application because otherwise the ability to tell the filing date of the publication might not make sense. But for every patent application, there's a filing date assigned to it. And so that filing date, even if the publication date is after your invention is filed, relevant date for A2 prior art is the filing date of that prior application. So that's it. We've gone over really briefly what qualifies as prior art as defined by Section 102 in Title 35 of the U.S. Code. You should now be able to review documents and determine if they qualify as prior art relative to your invention.